Good afternoon, everyone, and welcome to this Francis Taylor Building webinar on local planning authorities and the DCO examination process. And the point of this afternoon's webinar is to look at the DCO process and the point of view of the local planning authority, who play a very important role at the moment in the examination of DCO projects, and also take a look at what might happen once the government publishes its guidance and what the changes to the pre-application process will be and how that might look for local planning authorities. The intention of this afternoon is to provide very much practical tips for local planning authorities and those involved in responding to NSIP DCO applications within their local authority area, but it will also be of interest to developers who may be making applications for DCOs and who want to consider the way in which they frame their engagement or responses to local planning authorities. So in terms of the agenda for this afternoon, we're going to start by having a brief reminder of what a DCO regime is. So maybe some local authorities who have not had a DCO examination process before, and maybe the first time they've had an NSIP come forward for their area. So it's useful to have a brief reminder of what an NSIP is and the overview of the DCO process. I then propose to look at the role of the local planning authority at pre-examination stage, during the examination itself, and also post-examination, because once the consent is granted in the form of DCO, there's actually quite a lot still left to do for the local planning authority. Then we're going to pick up some practical tips for local planning authorities before considering the proposed reforms anticipated to come forward to the DCO process, and then we will conclude. So in respect of the introduction to DCO and NSIP process, and a brief reminder that what DCO is, unlike a planning permission, is it is in effect a piece of legislation. It's a statutory instrument granted by the Secretary of State that authorises what are known as nationally significant infrastructure projects. And the governing regime at the moment is set out in the Planning Act 2008, which is to the NSIP DCO regime what the Town and Country Planning Act 1990 is to the planning permission regime. And the clue really is in the title. These are projects which, as a result of their scale, their quantum, their generating export capacity, means that they are significant projects, not just at a local level, but ones of national significance. And what we are very much thinking of really is development in the fields of, for example, energy. That could be renewable energy, that may be old-fashioned energy, and maybe, for example, nuclear fusion anticipated to come forward within this country. It may be transport, so airports, large road schemes, water, wastewater schemes, waste schemes, etc. And the question of whether or not a specific project is an NSIP and one to which the Planning Act 2008 applies is governed by the thresholds which are set out in the legislation itself. And the position is that if you exceed those thresholds, well, then you will be an NSIP for the purposes of the Act. And the key consequence of this is that rather than making an application to the local planning authority for planning permission, what the applicant has to do is to seek a development consent order from the Secretary of State. And that process is one which is both rigorous, as you can imagine, due to the scale and significance of the projects, but also a highly structured process because it is one which follows along the very clearly set out stages within the legislation and within guidance. The DCO regime is mandatory. You don't have an option if you exceed those thresholds to seek and to obtain a different consent. And that's important. And that's why, for example, one often saw clustering of, for example, solar farms at just below the NSIP threshold so as to avoid a DCO application. It is possible, however, for directions to bring what would otherwise be a development underneath the threshold into the regime. And again, the wide-ranging nature of the DCO, it being a creature of statutory creation, is that it can include compulsory acquisition powers, it can grant powers to stop up highways, it can grant listed building consent, conservation area consent, etc., and other powers, all of which means that effectively it can be a one-stop shop concept for your project. So the aim of the government in enacting the 2008 Act was, as we've said, to have a one-stop shop and to replace and remove the need to have multiple separate consents. So it means there's one application and one examination process. And similar to the way in which the local authority can impose planning conditions on a grant of planning permission, the Secretary of State can impose what are known as requirements, which are the equivalent of a planning condition. One important area to be aware of within the world of NSIPs and DCO examinations is the importance of national policy statements. They set a framework for decision-making in DCO applications, and the Secretary of State is under a duty to have regard to the relevant national policy statements. And unless a specified exemption can be made out, the Secretary of State is under that duty to decide and determine that application in accordance with a national policy statement. So in terms of the key protagonists and antagonists as part of the DCO process, those are the applicant, who may be an energy developer, they may sometimes be a central government department themselves, etc., but they will be somebody who of large support. They will have a large consultant team, etc., behind them to help them make that application, which is a demanding process. The local planning authority, as we will see throughout this afternoon's seminar, is also key, a body as part of the process. The planning inspectorate is, of course, responsible for the administration of the examination process, and the examining authority, who is appointed by the Secretary of State, will be responsible for conducting the examination of the application and ultimately making a recommendation of the application to the relevant Secretary of State, and it will be the Secretary of State who will make the decision at the end of the process. So turning now to consider what are these stages in the DCO process. Well, there are 6 principal stages, and the first of which is the pre-application stage, and the intention of the government has been that it should be a front-loaded process, i.e. quite a lot of the hard work and the heavy lifting ought to be done prior to submission of the application for examination. At the moment, that is characterised primarily by extensive consultation and engagement, but it's important to have regard to the proposed reforms, for example, as a result of the Planning and Infrastructure Act, and it's also characterised by intensive document preparation, and a local planning authority may co-author, for example, quite a lot of the documents. The next stage is acceptance. So the applicant, once it has complied with what's expected of it prior to submission, submits the application to PIMS, who determine whether or not it is ready to be accepted. If it is accepted, we move to the examination stage and to the pre-examination stage, at which point the examining authority is appointed. Interested parties will register, and a preliminary meeting is held, which you can consider as akin effectively to a case management conference. We then move to the examination stage, which lasts approximately 6 months, and that's primarily a written process, but at regular intervals throughout that. Hearings are held by the examining authority, and local planning authorities will attend those hearings, in addition to the applicant, other consultees, such as the Environment Agency, the Highways Authority, etc., as well as interested parties, local residents, landowners, parish councils, etc. It's much more of an inquisitorial as opposed to adversarial process, however. The examining authority will put out an agenda in advance. They would expect to lead a structured discussion, and one wouldn't expect to see, unlike an inquiry, for example, any cross-examination or formal presentation of evidence. And the majority of the heavy lifting of the evidence is to be done in writing. We then move to the decision stage, and we can expect a report from the examining authority, which will then be submitted to the Secretary of State, who will then make their decision. And then post-decision, and this is actually a very important stage for local planning authorities, because they will be involved in, for example, the discharge of requirements, considering the question of enforcement if that becomes necessary. So moving now to consider the role of the local planning authority in the pre-examination stage. And at the moment, as we have said, the process of engagement at the pre-application stage is governed by the legislation and is a duty on applicants to consult the local planning authority and to carry out wide-ranging pre-application consultation, and that's set out in legislation. But as I mentioned earlier, the government has, through the Planning and Infrastructure Act 2025, made a number of very significant reforms to the consultation process, and they have removed that duty of consultation, including with local authorities. And that is a significant streamlining of the pre-application process. The point being to give legislative intent to the government's policy objective of ensuring the DCO applications are determined swiftly and the challenges, for example, by way of judicial review are dealt with expeditiously so as to reduce delays to what are seen as critical infrastructure for the government's priorities. The local authority will also be responsible for responding to, for example, EIA scoping reports, engagement with parish councils, the local community, etc. And that's quite important because the role of the local authority at examination is to effectively present and to ensure that the role of the local authority, that the views of members, the views of the local community are given credence as part of the examination process. And to properly perform that role, it's important that local authority officers understand what the position of members is, what the position of the local community is. And it's very important for local authorities to realise that engagement gives it a really important opportunity to develop the scheme through collaborative working. Local authorities have the benefit of local knowledge in a way that, for example, our applicants may not. And through proactive and collaborative engagement with the applicant, it is possible, even at an early stage, to shape the design and to ensure that mitigation is secured and that is adequate mitigation. And although the government has now enacted legislation to remove the statutory consultation duties, and we await the publication of the guidance, which we anticipate later this year in the summertime, it is important to realise that even in the new regime, as it will, that drive for engagement, that ability to have a direct conversation with the applicant, to actually drive changes to the design and mitigation of the scheme is still going to be extremely important. It's also important, of course, that the local authority makes sure that it is registered as an interested party and that it begins to consider what it may wish to say in any written representation in due course. It's also important to consider the question of planning performance agreements so as to negotiate those to help resource and fund local planning authorities' engagement, because the process of a DCO examination is extremely time and resource heavy. It demands a lot from local planning authority officers, and this will be at the same time that you are still performing your development control, your policy functions, and dealing with ever-changing national and local policy. So it is a very heavy and onerous responsibility for local planning authorities, and it is critical to ensure the local authority is properly resourced and funded. So, in terms of what the local authority might do prior to pre-examination, it can begin to think about the appropriate delegations and who its team might be for examination. And it's very important to ensure that the right delegations and the right resources are in place from an early stage so as to minimise delay to getting the examination ready. It will also wish to think about who its team for examination is likely to be. So within the local authority, who are the right people to be participating? Do we need highways expertise? Do we need our landscape expertise? Do we need infrastructure funding expertise? Do we wish to look at external witnesses? Those are all questions that need to be considered at an early point. The local authority should also begin to prepare the local impact report. I'll talk about that in more detail in a moment, but that's a very important document, and again, a way in which the local planning authority can bring its knowledge of the local area to bear in the examination process. It should engage with the applicant so as to support the preparation of the statement of common ground. It should identify key concerns and priorities for the authority at an early point, and that will require engagement with both cabinet members and elected members to understand what the political aims and drives of the authority are likely to be. The next process will be to attend a preliminary meeting at which there will be an engagement with the examining authority on the timetable for the examination and procedural matters. And at an early stage, consideration should be given and to whether or not it is appropriate to instruct counsel so as to assist the authority with representation at the examination. Moving now to the examination itself. And as I said, local impact reports are a really important way in which the authority can bring its expertise to bear on the examination process. So a local impact report is defined by Section 60, subsection 3 of the Planning Act 2008 as a report which gives details of the likely impact of the proposed NSIP development on the authority's area or any part of its area. So in terms of topics for the LIR to consider, that will include the planning history, relevant local policies, pipeline development proposals within the area, the local area characteristics, transport patterns and any site patterns rather, and any site constraints. The key points about the LIR is that they are separate from written representations. The purpose is to make the examination authority aware of the impacts and for that analysis to be informed by the local knowledge and expertise of the authority. The authority is under a statutory duty to prepare that LIR, and therefore it's important to recognise that this is not an opportunity to assess the merits or otherwise of the development proposal. That is a job for the examining authority, but rather to detail neutrally what the likely impacts of the development may be. Moving then to the question of written representations and statements of common ground, there will be deadlines set in the examination timetable for the submission of written representations, and that will be the opportunity. And as I've said, the DCO process is primarily a document-heavy one. It's driven by the evidence in writing, with hearings simply a chance for the examining authority in its inquisitorial form to understand the party's position. But it's really important, therefore, the key points are covered in the written representations. And not only do the LPA set out its case and the key issues in the examination, but also an opportunity for it to respond and engage with submissions made by other parties, including the applicant. The statement of common ground is also extremely important in a DCO examination, and as you would expect, and similar to its role in a local in a planning process, it sets out areas of agreement and disagreement with the applicant. The authority will be responsible for supporting the preparation of that draft document and also the issues tracker, which will be a movable document as the examination progresses. And it will also be responsible for finalising that statement of common ground by the end of the examination process. There's also a document to be aware of called Principal Areas of Disagreement Summary Statement. And in some examinations, the examining authority may request this document, which basically sets out the issues that the examining authority needs to grapple with in this report. What are the unresolved areas of dispute between the applicant and the local authority? Turning then to the question of attending hearings, and as I've said, unlike, for example, the process of local planning inquiries is a much more of an inquisitorial process without live evidence in the form of examination in chief and cross-examination. The various types of hearings that take place throughout the examination process are as follows. For example, issue-specific hearings, which are focused on particular topics, and the inspectorate will circulate an agenda prepared by the examining authority in advance. Compulsory acquisition hearings. As I've said, DCOs can authorise compulsory acquisition, and therefore there will be hearings to consider the question of land take and rights. There will be open floor hearings at which anyone can come before the examining authority and speak, and there will also be hearings at which the detailed drafting of the DCO will be considered. And at those hearings, the local authority will wish to take a view as to which hearings it wishes to be represented at, to participate in, etc., and which are the key hearings for the purposes of driving the local authority's agenda. It will also be necessary to respond to written questions which will be published by the examining authority, in which they will seek specific responses to specific questions of the parties, and there will also be site visits. In terms of examination participation and ensuring the local authority takes a meaningful and valuable role both in assisting the examining authority but also in putting forward what it wishes to achieve from the outcome of the examination itself, it's really important to focus on what really matters to the authority and to maintain a dialogue with the applicant throughout. As I said, in collaborative engagement can be really productive. It's important for the local authority to be clear from the outset about what it is it actually wants out of this process. Is it a refusal of the application? Is it the imposition of certain requirements or obligations to make it acceptable? And all of that will be really important to understanding the shape in which any advocacy at the hearings should take, or what the form of any response to, for example, examining authorities' written questions should be. It is important, however, that irrespective of what decision is made and what the best outcome for the authority is, that active participation takes place as part of those hearings in order to ensure the examining authority is aware of the authority's position. And that's one instance in which it can be quite crucial in some instances to consider whether or not it is appropriate to instruct cancel. Turning to the post-examination stage, and dealing first with the decision stage, the examining authority has approximately 3 months to write its report after the close of examination. So that's a labour-intensive process for the examining authority, who has to deal with the volume of documents produced throughout the examination process. It will then make its written recommendation to the Secretary of State, who will consider the examining authority's report. It has 3 months to decide the application, and the relevant Secretary of State, so for example, for a highways or airport scheme, and maybe the Secretary of State for transport, they will have 3 months to decide the application, and throughout that stage, it is possible for them to ask for additional information. And so local authorities shut and switch off, as it were, during the stage in which the examination has concluded and it is with the Secretary of State for a decision, because it is possible you will have to respond to additional information requests. Once the decision is made, irrespective of the outcome, there's a period during which, a 6-week period, it will be open to parties or local residents, etc., to seek to challenge any decision in the High Court. And you will be aware that the Planning and Infrastructure Act 2025, primarily as a result of the review undertaken by Lord Banner into the NSIP process, has made a number of important changes to the challenge process, which would be challengers, but also those who are responding to any potential challenge need to be fully aware of. So, assuming a decision is made to grant DCO, the local planning authority actually has a very significant role to play at that stage and throughout the implementation of the DCO in the project itself. And that takes the form of the discharge of conditions, monitoring development, and also potentially enforcement. So, as we've said, requirements are akin to planning conditions, and therefore there's an ongoing role on the part of the local planning authority to be responsible for approving details, for example, submitted pursuant to any requirements. There will also be monitoring and enforcement powers. It's a criminal offence to breach a DCO. And the authority will be responsible for considering whether or not enforcement is required if there has been an authorised development, and to consider what enforcement powers may be open to it. It's also important to recognise that applications may be made for material changes to a DCO, and there's also a power to apply for the revocation of a DCO if, for example, development was abandoned having been started, and that was having an adverse effect on the amenity of the local area. So, turning now to the practical tips for the local planning authority, it's important to recognise that, as we have said, it is a resource-heavy process which demands quite a lot from the local planning authority, and it is important, therefore, to recognise there are a number of steps that can be taken at an early stage to ensure that the authority is ready to hit the ground running. And one of those is to ensure that early engagement and preparation is taking place. So, if there's a proposed application, and it's possible to look at the government's website to identify all those DCO projects which are currently at pre-application stage or are going through the application stage at the moment. And it's important for authorities to be aware of what is potentially proposed for their local area. And rather than waiting for the applicant to make contact with the examining authority to publish a timetable, it can be useful to have engagement at an early stage. And I think that informal engagement will become even more important once the mandatory consultation requirements have fallen away as a result of the recent legislative changes. It's important to recognise, of course, that engagement should be treated as akin to support. So even if the authority's position is that it thinks the DCO application should not be granted, it's important to deal with the counterfactual, i.e. what may happen if that is going to be approved by the Secretary of State, and to engage to ensure that even if it's not what the authority wants, ultimately a better design comes forward, that the project leaves a better legacy behind it, and iterative and collaborative engagement with the applicant can be key to that. It's also important that the authority identifies its concerns and priorities at an earliest opportunity, and to ensure that there is consideration of the views of the Cabinet, of members, etc., and to ensure that officers are aligned to what the political objectives of the authority may be. One really important practical tip is to try and identify a point of contact in the applicant team, because you as officers may very often be contacted by elected members who will be raising questions with you about one aspect of a project. And if you can have a dedicated go-to contact within the applicant team, that can be really useful. That also allows you to build trust and a working relationship, which can be really important for the post-consent engagement. So, for example, throughout the process of discharging the obligations and requirements imposed on DCO, if you have a valuable and trusting working relationship with the applicant, that can make that process easier. Adequate resourcing can be a concern, so it's important that there is internal engagement within the authority to ensure the adequate resources are in place. It's always important to seek agreement. So there may be other local authorities who are involved in the DCO process, depending on the scale of the project in question. There should be coordination and engagement with those authorities, and indeed with other statutory consultees, like, for example, the Environment Agency. As I've said, it's important to have regard to the views of members so as to avoid a public and obvious display of attention with political direction. That may become more apparent given recent changes within political makeup of local authorities across the country, and the indications of some parties as to what their views are about NSIPs, and particularly solar projects, wind energy projects, etc. But it's also necessary to consider as well whether or not any changes in political direction will have implications for what local authorities are allowed to say by their members at examination process. Having that direct early engagement can avoid any embarrassing moments during the examination process. It's also important to agree the appropriate delegations and decision-making processes early. So you should have regard to your scheme of delegation to ensure that you understand who's responsible for signing off documents, and this can be done in time and without missing any of the deadlines set by the examining authority. Is it necessary, for example, for Cabinet members to approve positions publicly taken by the local authority? But it's really important to know the answer to those questions by reference to your own internal arrangements, and ensure the clear authority for officers has been put in place. It's also necessary, as we said earlier, to ensure that the appropriate team is put together. And it should be necessary at that point to consider again whether or not it's appropriate or necessary to engage external expertise and legal advice to support the local authority. At the examination stage and beyond, it's really important when preparing for examination and examination hearings to identify the most important points to take through to the examination. It's important to have a working timetable, and what I'd suggest is that once you have the published timetable for the examining authority, you build a timetable building back from those deadlines to ensure that people's diaries and workloads are managed, to ensure that capacity is there at the appropriate times to respond to deadlines. So it's very important, for example, to be ensured that people are aware of when annual leave should and should not be taken. If there are chances for junior officers to take an active role, that can be really important to ensure that you build and develop your internal capacity so that they can take on an even more active role when it comes to the next DCO examination. After the local impact report, it's not the local authority's job to assess the application on its merits, but it's still important for it to understand its key battlegrounds. That said, it's important to be adaptable. Throughout the process of a DCO examination, it is important to understand that the environment in which you are responding to the application will change. For example, the national need picture may change. The national policy picture may change, the position and makeup of the authority politically may change, and indeed the views of elected members may also change. And it's important to realise that barristers can act as a critical friend in assessing the robustness of the authority's position. Another key tip is to understand and communicate resource implications. As we've said, it's extremely resource intensive, both financially and in terms of human resources. So it's important to make the case internally for adequate resourcing for your team. As I've said, you should seek to align officer and political views, so to ensure consistency across various disciplines, be that planning, highways and the environment, and also seek to align advice with members' positions. So that's why engagement with members is really important. It's also important to understand and to communicate to members and the local residents that it is not the local planning authority's role to determine the application, simply to inform the examining authority and influence the process. And as I said, being clear about the outcome the authority wishes to obtain is very important. So in terms of expectations and how this process can best be influenced and how collaboration can best be driven between applicants and the LPA, both for the benefit of the scheme itself and also in terms of local outcomes. For local planning authorities, this can be achieved by demonstrating a transparent approach, by seeking meaningful mitigation, by engaging early with the applicants, by seeking to collaborate on documents like the Statement of Common Grounds, and by working together with the applicant to make the post-consent delivery and implementation stage easier. On the converse, applicants should, and the local authority should try and create an expectation on the part of the applicant that this is what it expects, that meaningful mitigation will be offered, that the applicant will recognise and respect the demands that the DCO process places on the LPA, while also recognising and respecting their local and specialist knowledge, and also that communication takes place. And that those sort of expectations and approaches to the DCO process can really help to deliver better outcomes for not just the applicant and the scheme itself and the local authority, but also widely for the local community. In terms of reforms to be aware of, as we've said, the Planning and Infrastructure Act 2025 has received royal assent. Some parts are already in force. For example, the reforms that have been made to legal challenges, the reviews of national policy statements, etc. But the most important for local planning authorities to be aware of is what's going to happen when it comes to consultation requirements. And the government has removed a number of very important parts of the Planning Act 2008, which had previously set out the strict requirements of pre-application consultation, including the requirement to consult the LPA. That's a very significant reform. And what we're going to be left with in its place is what is going to be governed primarily by guidance published by government. That is expected to come out in early summer. We were told by the recently published implementation plan that was published in April this year. It hasn't yet been published, but that will be essential reading for all those involved in the NSIP DCO world. The question will be, how do LPAs shape schemes in the absence of those mandatory provisions? And the answer to that will depend on what the guidance says. But plainly, applicants will still have to engage with local authorities and statutory consultees. So much of what we've said about the importance of early engagement, the ability to drive amendments to secure better designs and better mitigation, will plainly still be very relevant. There is a query, of course, at least to my mind, as to how those reforms will be effective if the government's drive is to streamline the process and to drive with pace the delivery of NSIPs and DCOs, well then, if pre-application engagement and consultation, which has been very important and very effective at ensuring schemes are well designed, is effectively minimised, does that not undermine the drive for front-loading and run a risk that the examination process will become more tortured and more onerous? I mean, all of that, whether or not that becomes a reality, will depend on how that guidance is drafted and what it looks like in practice. There have also been some reforms in the acceptance stage which will be relevant. There will also be new duties on the local planning authority when it's preparing its local impact report. It will be required to have regard to the Secretary of State's guidance, and it will also be required to have regard to guidance when it's making its written representations. And there are also changes to the DCO amendment process, and you should also be aware that the infrastructure planning fees regulations 2026 will allow you to charge fees for services connected to NSIPs, and that may be a significant new income stream for host authorities. The commencement timeline, as I've said, some parts of the Act have already commenced, other provisions will commence throughout this year, and regulations are still required to actually commence and set out the commencement timetable for some other parts of the Act. But very plainly, it's a very important piece of legislation which makes a number of very significant changes to the DCO NSIP regime. Turning then to conclusions. So the key takeaways in this afternoon's seminar ought to be as follows. Firstly, the local planning authority are vital participants throughout the DCO process, and that's the whole way through the process, in the pre-application stage right through to post-decision enforcement and implementation. The second takeaway is that early engagement and preparation is essential. There is an ability through that engagement to seek to shape the project before the application is submitted, and for the authority to identify its priorities and agree internal processes early. The authority should focus resources on what matters most, the local impact report, the key issues, and securing appropriate requirements and obligations. The next takeaway is that what is required is a sustained input throughout the process, and dialogue should be maintained with the applicant and the examining authority, and it's important to be clear and consistent in local authorities' position throughout. The reforms ahead, the two main areas to be aware of, as I've said, are the significant changes to pre-application and examination stages introduced as a result of the Planning Infrastructure Act 2025, and the guidance will be essential for understanding how that will all look in practice. And in terms of fees, to be aware that a new fee charging powers will be an important resource for ensuring that the authority is properly resourced and funded so as to engage with the process. Well, that concludes this afternoon's webinar on the DCO process, and in particular the role of local planning authorities as part of that process. We have a number of questions in the Q&A section, and anybody else who would like to put in some questions is certainly able to do so. In respect of the Section 62 of the Planning Act 2008, yes, George, as you say, where one is invited to submit a local planning authority, at that stage that would become a statutory duty to do so, i.e. being invited by the examining authority to do so. So although it's sort of expressed in a way to suggest that's an invitation you don't have to accept, it is a duty to prepare an LIR, and it's a very important way for you to do so. In respect to the principal areas of disagreement document and what that relates to and how that can still be effective, notwithstanding the fact there's a comprehensive statement of common ground, that really is informed by the discussions that take place at the examination itself. So at the statement of common ground stage, you may have areas of disagreement, areas of agreement, but the purposes of the principal areas of disagreement document is really to set out, once the discussions have taken place at the examination, what is the main areas of disagreement left, what are the parties' positions, and what are the issues that the examining authority really has to grapple with. So the importance of that document is really to help the examining authority. And I see, yes, there's also a question about, yes, the charging, yes, the requirement of a charging schedule to ensure that you can properly charge fees as part of the infrastructure regulations. Yes, and also we will be circulating the slides for this afternoon's seminar to all those who've attended to start tomorrow or this afternoon. So thank you all very much for your attendance. Unless there are any further questions which you can pop into the chat box, that concludes this afternoon's webinar, which I hope you have found to be a useful process. Thank you all very much, A, for attending, and also B, for your continued support of France Sustainability, and we trust this has been a useful afternoon. Best wishes.